Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page 3.
Interrupt just a second.
Yeah, of course.
IT is about to create a new secure Zoom link, but it's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry, continue.
That's okay.
I apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entering Mr. Williams' home. Then there are two parts here, and that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant, and what did they see once they got inside that would rise to probable cause? Then, skipping, Your Honor, to line 21, same page 34, this is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve-out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went in home, they allegedly found marijuana, guns, other contraband, and that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said, at the end of line 1, Your Honor, or it's the middle of line 1, an arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within. The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional rights violated. He's a victim. The court should say respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door, and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct, and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to effect the arrest warrant. And then we get to the second point, and it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor on page 36, line 25, concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom, and Detective Gaither further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appealed. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A+ game and try to win before this court. That's not the way. I don't get to do that, ever.
But it wasn't appealed. I mean, there wasn't, Judge Newkirk's ruling could have been appealed by the state, or could have been appealed by you within 30 days of the entry of the order.
Why would I appeal it?
Well, no, you wouldn't appeal it. But...
And the state doesn't appeal it. What does that mean? It becomes final. The court cannot amend that order. You'd be amending the finding between the same parties on the same exact issue. They don't get the second, in the case law it says second bite at the apple. Then, Your Honor, on page 38, line 14, this is the district attorney again. So it's just not an issue that makes any distinction or any difference. It's clear here that it's clear here they, meaning the police, had authority to go in to effect the arrest warrant because Mr. Williams wasn't outside the house and he didn't come to the door. Once inside, law enforcement saw illegal contraband drugs. That is probable cause to get a search warrant all day long in any jurisdiction in the state. Your Honor, the police had no right to enter. That ruling was made. I then say on page 39 of the same Court's Exhibit 2, line 1, I get to speak. The court gave me an opportunity to speak. I said, thank you, Your Honor. Your Honor, we are traveling under, I'm assuming the court has it. If not, we'll get you a copy. There was a supplement to motion to suppress, and this is what I'm stressing, sir, the Honorable Judge Glanville, any and all evidence located lawful, and his arrest would be unlawful. And then the fruits of the unlawful arrest may not be introduced into evidence. An arrest warrant was never part of the record below. An arrest warrant not put in evidence was not put in evidence while the witness testified or at any other time. The participants in the suppression hearing refer obscurely to the warrant, the warrant in the case. But there is no document to show that there is an arrest warrant. No judicial officer testified that he or she issued an arrest warrant. If the arrest warrant in existence, no reason whatsoever appears for the state's refusal to put it into evidence in the face of a demand. And I continued, I didn't write, I spoke, page 41, line 1. Mr. Williams demanded in paragraph 7 of the supplemental motion and challenged that there is an arrest warrant. If there's no arrest warrant introduced in the hearing, then we go down the road in kind of an outline. So if there's no arrest warrant before this honorable court, which there is not, then law enforcement officers, according to Sergeant Gaither, 30 or 35 law enforcement officers surrounding his home, Sergeant Gaither, which is G-A-I-T-H-E-R, did not go into the home. However, law enforcement officers entered this home. This honorable court has no evidence that they entered lawfully. Supposedly, he goes into Mr. Williams' bedroom. Now Mr. Williams is outside. So my first issue is the initial entry without the arrest warrants vitiates everything coming afterwards. That was my argument. On page 42, line 12, I argued to the Honorable Judge Newkirk. So my issue, I said right, period. So my issue before this honorable court is the first entry, obviously without the arrest warrant at this hearing, is unlawful. Then the second can't be saved by the second entry either, because that would be without lawful blessing, same thing as unlawful search, the second one we're talking about. Then the search warrant issue, this would be my third issue. So first one, no arrest warrant. I am challenging, it is clear to everybody, including when you read the state's motion for reconsideration that I've already entered, Your Honor, at the last hearing, everyone knew I was arguing that the entry into Mr. Williams' home was unlawful, and therefore everything in that home could not be taken, should have been suppressed and returned to Mr. Williams. And the state's reliance on Alford, State versus Alford, the state's reliance on this narrow window that only the Honorable Judge Newkirk suppressed marijuana is frivolous. On page 43, starting line 4. I continued. But then when the court goes through and looks at the search warrant itself, the only way we would have probable cause in the search warrant is if the court finds that law enforcement officers on the day that this happened actually had the lawful right to go in the house and to observe, because everything else in that search warrant does not produce probable cause to search Mr. Williams' home. Then it continues on page 45. On line 4, at the end, I say in the middle of the sentence, nothing is attached showing that this arrest warrant was valid from DeKalb County. On line 40, page 46, on line 5, the next issue, Your Honor, that is asserted is that law enforcement officers entered Mr. Williams' home on the day that we're talking about, and I challenge that in the supplemental motion with the fact that it was read to this honorable court by the district attorney, supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home because I'm challenging the arrest warrant was not valid if there is an arrest warrant. And the last issue in the affidavit for the search warrant discusses items that were located by law enforcement officers during the search on the day that you heard about, which I would say is a fruit of the poisonous tree. So I have 3 issues. 1, there is no at all arrest warrant presented to this court. So under Baez, which I have a copy for the court, how can I challenge the arrest warrant? How can the court say it's a lawful arrest of Mr. Williams at his home without being armed with a certified copy of the arrest warrant? Therefore, and I stress this, Your Honor, everything thereafter falls as fruit of the poisonous tree. On page 47 of the transcript in courts number 2, on line 9, I continued. So the only thing we're left with is the unlawful entries into Mr. Williams' home, and I would ask the court, based upon that, suppress the evidence, grant the motion to suppress. Mr. Bailey then speaks on page 47, line 14, and going to line 18. At the last word, he says, this motion to suppress the search of a home that the defense is alleging is illegal. Nobody's talking about only marijuana. Mr. Bailey continues on page 48, in line 10 in the middle. The only 2 questions, Your Honor, are, did they have reason to believe Mr. Williams would be there, and so they could go into the house and get him? That's it. And then secondly, once they're in the house, did they see something that would give them probable cause to obtain a search warrant? Those are the 2 issues, not whether the arrest warrant out of DeKalb County was valid and whether the case was eventually dismissed or anything like that. The court then, on page 49, on line 6, says to the state, in which case you would have produced a copy of the arrest warrant. And Mr. Bailey says, right, which would have been a subject, I'm sure, of the suppression motion at that point. And then the Honorable Judge Newkirk said, well, it sounds like Mr. Steele made the arrest warrant a subject of this motion, also in a supplemental motion which the court file does not have. What does it, what the prosecutor says, and that is the copy, the supplemental one. Again, he's not challenging the arrest in this case. He mentions something in there about DeKalb arrest warrant. If he wants, there's no need to challenge the DeKalb arrest warrant now because the case was dismissed. But there is a forum for doing that, and that may be what they did in the case. Maybe they challenged the arrest warrant in that case. On page 51 of courts number 2, the district attorney states on line 6, that doesn't mean that because there's not a certified copy of that arrest warrant that has any bearing at all on whether the entry and subsequent search of this house was proper. Everyone's talking, Your Honor, about the entry. That would be the state's argument in the case. At line 11, the Honorable Judge Newkirk said, all right, tell me again about Baez. I'm not familiar with it. What is the site? Is it Supreme Court or Georgia Supreme Court? I say Court of Appeals. I give the court the site. And then on line 51.
51, okay.
Yes, sir.
All right. Yep.
And then on line, the court asked me for a summation on Baez again, and I said, okay, that's on line 22. So it's a motion to suppress like we're dealing with here. Law enforcement officers have obtained a search warrant after an arrest warrant. So it's the same sequence here. Going on to page 52, Your Honor. Law enforcement officers utilize the arrest warrant. They call it several things, bench warrant, arrest warrant. And just like Mr. Williams, it was challenged whether it was a valid arrest warrant. The motion to suppress hearing goes forward. The prosecution doesn't put forth the arrest warrant. The Court of Appeals says without the arrest warrant, it is not in the record. We are not finding there was an arrest warrant. It was challenged, and they suppress the evidence and find it is a fruit of, since there's no basis in the record to have an arrest warrant, everything thereafter is unlawful. That's exactly what I think happened here. That's why I used the case. Why did I make the supplemental motion to suppress all evidence located from Mr. Williams' home? Your Honor, I was challenging everything. It is clear. And I'll get to the Judge Newkirk's order, because it's not a fair reading of the order to say only the marijuana. That's not true. I didn't write that order, by the way. On page 52, line 23, I say, and I don't want to play games with anybody. I put it in its own paragraph. I made it a supplemental because I realized there was a problem with the arrest warrant. So I made paragraph 7 standing alone, or standing on its own, and I wrote, moreover, law enforcement officers were not armed with a valid arrest warrant in DeKalb County at the time of entering Mr. Williams' home, and thus, and Your Honor, I'm stressing this, all evidence must be suppressed on page 53, lines 1 through 5. Then skipping to line 15, I again plead to the Honorable Judge Newkirk, the law should be followed in this case, and I say, but I guess it goes back to if the first arrest warrant is not before this honorable court, according to Baez, it was challenged, just like I challenged it on behalf of Mr. Williams, then how can this court sit here, the evidence that you heard, and say, well, there's a valid arrest warrant? We challenge that there's no valid arrest warrant, and then it's not saved later, in my opinion, the search, because I don't know how else law enforcement gets in the home. Because now, you know, thank God there's not a shootout in the house where law enforcement had to go there. On page 54, line 5, Your Honor, I continue, so I don't know how law enforcement, without a valid arrest warrant here today, has any evidence to go before the court, and that is why I made an issue of the other items in the search warrant, like the confidential source, the alleged confidential source, the murder of Mr. Thomas, because all of that doesn't save the search warrant, so that's why I thought it was important. The court states, the Honorable Judge Newkirk, on page 55, its ruling. On line 18, the court says as follows. All right, Mr. Steele, I'm going to go with you on this. I think you are correct. I think the burden is on the state to show the initial arrest warrant was valid and initial entry into the house was valid. And he hasn't done that, meaning the prosecutor has not done that. It appears there's no testimony from any officer. Certainly, there's no need for her to go back in the house without a search warrant. It doesn't sound like she searched for anything, so that might have been harmless, excuse me. That might have been harmless error because the arresting officers discovered it and went out and told them. And this is what I'm stressing. Line 4, page 56, the Honorable Court's ruling. But I don't think we get to that hurdle because the lack of authority shown to the court that they had permission, meaning the police had permission to enter the house on the front side, So I will grant your motion, Mr. Steele, if you will prepare a proposed order. I never did the proposed order. I don't know why I wouldn't do that when I'm told. Maybe I did and the judge didn't like it. That's not my order. The bottom line I'm trying to tell this honorable court with as much earnest and power and professionalism as I can is I do not want to relitigate this after I gave a roadmap to the prosecution on how to litigate. If they need me to help them litigate a case, I'm not helping them. The issue here is we had the hearing. I challenged the initial entry into Mr. Williams' home. He is the victim of constitutional rights that have been violated, and the state doesn't get to go back and do it again. Then Judge Newkirk's order, if you look at his order carefully, Your Honor, he does not just suppress marijuana. The prosecution, and they're great people, but on page 33 is all they want you to do, Your Honor. They want you to be in your foxhole and just focus with tunnel vision and say when the judge said all he's challenging is the marijuana and act like, well, that's all there was. The judge found that the entry was unlawful. We don't get to do it again. And Mr. Williams then tried for a year and a year to get back his property. And what did the police do? They tell him, it's the evidence. We're not giving it to you. The statute says it. And now, today, the state wants to come in and say, well, we had another search warrant. I will talk about that search warrant in a moment. Let me just show you, if you don't mind, the order of the Honorable Judge Newkirk, which I forget the number.
It is D4.
And, Your Honor, in the...
That's the first one.
Thank you, sir. And it's entitled, it's filed, I know the hearing was on the 3rd of April, 2017.
Filed in on the 11th of April,
Right.
2017.
So D4, order granting supplemental motion to suppress, and I'm stressing it, any and all evidence located from defendant, excuse me. It's Mr. Williams' home. It says, it's used defendant's home. After hearing testimony, a stipulation of testimony, an argument from the parties on Monday, April 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. There is nothing clearer in the world of what was suppressed. The prosecution is intellectually not being straight. Based on this ruling, meaning everything's gone, the evidence located in Mr. Williams' home that is subject to this accusation. That's all. The accusation was just a marijuana case. Specifically, just over an ounce of marijuana is hereby suppressed and cannot be used in evidence by the prosecution in the trial of defendant Williams. Do you know where the judge got that language from? I know I didn't do this order because I would always say the honorable court. This is just not the way I'd write an order. But you know where the court did get the language of what the state was relying, specifically just over an ounce of marijuana? It's in my motion. I said suppress everything, specifically including the marijuana. It is not true what they are telling this honorable court, and that's not acceptable. Then you go to the search warrant. The state wants to rely on a search warrant from 2016. It was signed by the Honorable Judge Woodson. It is signed, and it's in your court's file. I believe it's defendant's number 10, I'm going to tell this honorable court. And it was signed on June 27, 2016.
I have the warrant for search and seizure as D10. You introduced that last time.
So, Your Honor, this is the same items that were taken from Mr. Williams' home in July of 2015. It's the same exact items that should have been returned. The state of Georgia has a search warrant. What they don't tell you, and I'm not saying they're hiding it, they just didn't tell you, is that they couldn't get into Mr. Williams' devices. They sent it to Cellbrite with the search warrant. And Cellbrite wrote back, and the GBI, we can't get in the devices. The search warrant then is never applied for again to tell any court, like this court, by the way, there was a hearing and all the evidence was suppressed. The state is using then in May of 2017, after Judge Newkirk suppressed the evidence in April of 2017. The state then sends Mr. Williams devices when they won't give it back to him, they won't restore it to Mr. Williams or his father, who had a power of attorney, they'd go to Cellbrite. And Cellbrite now has better open the items. They don't get another search warrant. The legislature then says at the last 3 lines of this code section, Your Honor, any search warrant not executed within 10 days from the time of issuance shall be void.
Mr. Steele, sorry.
Mr. Steele, go ahead, sir. Yeah, go ahead, sir.
(17-5-25), the last sentence that the legislature taught us. Any search warrant not executed within 10 days from the time of issuance shall be void and shall be returned to the court of the judicial officer issuing the same as, quote, not executed. The state doesn't have a search warrant in 2017 in May. They steal Mr. Williams' property. They illegally enter his home. They steal his property. Then they keep it, the stolen property. They keep his stolen, the property that they stole. And then they go to Cellbrite and they ask him in May of 2017, after everyone's on notice that the motion to suppress was granted, not even appeal. They didn't have the guts to appeal. And say break into the devices. I mean, what are we doing here? And they want to do it again. I respectfully ask the court to enforce the collateral estoppel, res judicata, law of the case. It should have been restored. The police should not have had that evidence. It should have been given back to Mr. Williams. He shouldn't even have had to ask for it. And I think that State versus Alford, I'm sure the court has read it. It is telling the court something that the case does not discuss. It is just not even arguable that that case matters to this. They had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you asked me. I hope I answered your question, and I thank. I'll answer any other question, but I hope I answered your question.
You did, sir. You did. Ms. Rosenwald?
Your Honor, I know Mr. Steele has an interpretation of the language of the order.
I think that his interpretation is right. I'm just going to tell you that. I mean, I look at the way it's capped, it's styled and everything else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the through the poisonous tree. I mean,
so Your Honor, if I may, when I looked at this case first and I saw his motion, I I was sort of thinking the same way as the court. And then I thought, I'm going to check the case law. And I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the fruits of the poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think
though. That's the thing about it. I mean, I think it's clear from the reading of the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant, and he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted him for at that point in time. You had other things that were seized. Those things are fruit of the poisonous tree, or at a minimum should have been returned to Mr. Williams.
And so, Your Honor, I do want to pivot that if this court right now today says, hey, I'm wrong, and Your Honor finds that the cell phones are fruit of a poisonous tree, now and only now would Mr. Williams be able to demand his cell phones back. There has never been a ruling on the cell phones until this day, and I think that's really clear from the court's language in the transcript. Specifically in the transcript, the court says, and this is in the court's ruling, and Mr. Steele actually read it, it says we didn't get to that hurdle. So this is at page 55 through 56. The Judge Newkirk says it doesn't sound like she searched for anything. So that might have been harmless error because the arresting officers discovered it and went out and told them. But I don't think we get to that hurdle because of the lack of authority shown to the court that they had permission to enter the house on the front side. So I don't think we get to that hurdle. There is no ruling on fruit of the poisonous tree. There was no previous ruling on the cell phones. To the extent Mr. Steele wants to make an argument about the other search warrant in the other